Ms. Sophinas.
Good afternoon, Your Honor.
Yes, Your Honor, we understand that this matter is coming up for arguments as regards bail. From the onset, the Republic opposes vehemently the release of the accused person on bail for the single reason that there are compelling reasons to deny the accused person bail. And that will take the shortest period of time to lay both the legal and factual basis establishing the existence of compelling reasons to justify this court's denial of bail against the accused person. You know, I'll introduce our arguments on the law, then my learned colleagues will take it up on the factual matrix. You know, we trust the court's appreciation of the law on the question of bond. I think the superior courts have exhausted issues around it. But our application to deny the accused bail is based on Article 49(1)(h). Section 123 of the Criminal Procedure Code. Section 123, capital A of the Criminal Procedure Code. And paragraph 4.9A to L of the Judiciary Bail and Bond Policy Guidelines. You know, we preempt that the defense will tell you that bail is a constitutional right. We easily concede to that argument when they make it, that the right to bail is protected under Article 49(1). However, the same Article 49(1)(h) allows for the limitation of the right to bail, to the extent, therefore, that the right to bail is not absolute. You know, that limitation of the right to bail under Article 49(1)(h) is in line with Article 24 of the Constitution on the limitation of constitutional rights. And therefore, that it is our argument that denying the accused person before you bail would meet the threshold under Article 24 for limiting the right to liberty and the right to security of the person in an open and democratic society as is Kenya. The second argument that the defense is most likely going to raise is that there is a presumption of innocence. Again, we easily concede that every accused person has, under Article 50, Sub-Article 2A, the right to be presumed innocent. but the superior courts of this land, including in Abolfati versus Republic, a Supreme Court decision, has held that a denial of bail is not a violation of the right to fair trial and the right to be presumed innocent. So that this court, we pray, is not persuaded that if we persuade you, we have raised compelling reasons, and this court denies the accused person bail, the court will not be going contra the presumption of innocence. Your Honor, Section 123A of the Criminal Procedure Code, Cap 75, Laws of Kenya, together with paragraphs 4.9A to L of the Judiciary Bail and Bond Policy Guidelines, guide this court on what compelling reasons are. Again, the superior courts have held that the lists provided in those two provisions of the law and the guidelines are not exhaustive. Your Honor, outside the affidavit, which will be taken through shortly, it is a matter of public notoriety that the complainant in the case you're most likely going to be persuaded as to the conduct, behavior, whether or not the court believes that. It is our argument that a prosecutors, including the one speaking to you, and the judicial officer taking notes before this court this afternoon. An assault against a law enforcement officer, I dare say, is an offense against the state. That is a serious offense.
Bench is actually a party to this matter by indicating that bringing the bench in.
We give you a chance to rebut or otherwise. Don't give us addition that the bench is not part. Yeah. So let
and the intention is to actually derail me, so let me just try and get it back.
okay.
That the offense before you is of utmost seriousness. And if you look at compelling reason or of Section 123 capital A, exclusion to the bail and bond is the seriousness of the offense. Having said as much, Your Honor, with that uncompelling reason, allow me to just talk about two issues on the law. That the burden of proof of the existence of compelling reasons is, without a doubt, belongs to the prosecution, and that's why we're making these arguments. However, and more importantly, that the standard of proof so that should not be confused with the standard of proof in ordinary criminal trials. So that if this court finds on a balance of probabilities that there exists just one compelling reason, just one compelling reason on a balance of probabilities, then this court must deny the accused person bail. And allow me to address the last bit of must deny. While bail is a constitutional right, the Constitution commends that where there are compelling reasons, bail must be declined. So that the only discretion left is where their bail is granted, the court has a discretion to impose bail terms and conditions. However, if you find that there are compelling reasons, you must deny bail. To conclude, our application to deny the accused person bail is in the interest of justice. It is in the interest of the administration of the criminal justice. And Your Honor, I dare say that this court has a duty to send a warning police officer for whatever reason, even if he asks for 10,000 as bribe, as has been record, my Your Honor. But for whatever reason, even if for whatever reason, even if a police officer were to ask for a bribe, as they do, even if officer to be assaulted and to be robbed as is particularized in the charge sheet. You know, I will conclude by preempting arguments around a possible assault and or torture of the accused person to it in the morning, and I may not have a chance to respond, or maybe my colleagues will have a chance to respond. Your Honor, that while we take the alleged offenses against the accused person very seriously, the state equally takes allegations of assault The allegations are that there were any officers who assaulted the accused person, and I'm glad Mr. Ndegwa and Mr. Oka with me when we handled before Honorable Nina a similar case against Honorable Babu Owino in which and Gaucho, in which they were alleged to have been assaulted.
Yes, the only difference is that it's becoming preemptive after the victim has actually visited the hospital and before an application of that nature is made.
Then I'm allowed to preempt. If they don't want to make it, they can drop it. Yes. So I'm saying I am lucky that they're with me on the other side, because Honorable Nina dealt with that. It's not binding on you, but we will humbly persuade you that if the allegations that the accused person was assaulted by police officers, as I suspect it will be made, then the proper way to deal with that is to advise that the accused person be advised to visit IPOA so that a formal complaint is made about the specific officers or the specific police station. Because inviting you to talk or address the issues of the alleged assault would reduce this judicial office into an investigative agency. The only institution that is mandated and vested with powers to investigate allegations of misconduct against police officers is the Independent Policing Authority. So that issue cannot arise as part of the arguments for bond. You know, I've said enough. I will invite my colleagues, and thank you very much. I pray that the court may allow me to leave any time. Thank you. Thank you.
Good afternoon, Your Honor.
Good afternoon, Counsel.
Your Honor, I'll be taking the court through the compelling reasons as contained in an affidavit dated 5th June 2024, which is deposed by PC Josephat Rotich, a detective attached to DCI Kasarani, and who is the investigating officer in this matter. Your Honor, the affidavit has been served on the accused respondent, and the matter before you was commenced in OB number 2 of that June 2024. Your Honor, at the time that report was made, the accused respondent was still at large. And he was only arrested on the 3rd he was only arrested, Your Honor, from where he was hiding from. And Your Honor, the fact that he did not present himself to the station shows that he is a flight risk. Your Honor, we invite the court to take judicial notice of the notorious video that has been going around in social media showing the accused person freeing from the scene of that incident he's charged with. Your Honor, if you release the respondent on bail or bond, the state is apprehensive that he will flee from this courtroom too. And he will never be in court to face his accusers. Your Honor, that ground is captured in paragraph 8A of the affidavit. And Your Honor, taking you back to that video that is circulating on social media, which I've asked the court to invoke section 60 of the Evidence Act due to its notoriety, you will see that members of the public were in pursuit of the accused respondent. Not the complainant, but ordinary Kenyans, Your Honor. And we submit, Your Honor, that is a compelling reason showing that there is hostility towards the accused person from the public, which puts his life in danger. Thus, Your Honor, we are saying that the court should deny him bond to save from any person who may feel so aggrieved by the acts of that day. Number 8C, B and C of the affidavit formed by PC Josephat Rotich. Moving on to the next ground in which the state is seeking bond is that there is a likelihood that he will interfere with witnesses. Your Honor will still be asking the court to act, judicial notice, a social media posting which is doing rounds indicating that the complainant herein has been approached to drop this charge. Your Honor, person is in custody, but efforts are being made to interfere with witnesses. Your Honor, I'm referring to the social media post by one Mike Sonko, in which...
Your Honor, I think counsel, as much as I may not wish to object, cannot submit from the bar in such kind of weighty issues that affect the right of an individual. He needs to refer to us in the affidavit where that has been deponed. Where exactly is that affirmation in the affidavit that is referring?
Paragraph 8B.
Yeah, in respect to whatever you're referring to. Read for us, you see.
You cannot read.
You cannot refer to matters that are material.
Your Honor, kindly protect me from...
You're not under any attack.
I'm under attack from 3 counsels, Your Honor.
Your Honor, we are protecting the integrity of the process and the integrity of this court so that he does not make submissions from social media when he is appearing here from a court of law and is holding an affidavit. We are saving judicial time.
And I think these affidavits...
No, you're not the DPP. The DPP is the to respond.
I almost was. So, the affidavit dated 5th June 2024. What my good brother is talking to is what has been posted a few minutes ago. It can't be in the affidavit.
I think let's not forget.
Let him proceed.
No, according to Mr. Njoroge, his invocation is on the judicial notice.
It's judicial notice.
So you can,
And it's a matter of public notoriety.
But judicial notice must be a matter of notoriety.
yes.
That is not notorious to us. We are not in custody of that information. It's not notorious to us.
It is notorious to everyone else apart from you in this court.
All right.
We'll get your chance.
All right.
Your Honor, having regards to those overtures which have been made to interfere with witnesses, we will be treating and to be guided by where it is deponed that the feels victimized on social media and has requested before the accused person is released. That, Your Honor, will be a change of circumstance where the accused persons can approach this court after the complainant has testified to seek for bail and bond. Your Honor, you will also note that we did serve the affidavit. We have not received a formal response to that affidavit. We have also not received a formal notice to cross-examine the deponent. And we will thus be seeking the court to be guided by the averments in that affidavit.
Thanks, Yana. Mine is just a few things. And I wish to invite the court to look at paragraph 8, subparagraph A. And why we are telling the court that the accused person is a flight risk. We hope the court has had the benefit of seeing the video that has been circulating concerning the offense. And the accused person committed the offense around the morning hours. He was not arrested until the hours of night, for the very reason, that he went into hiding. The police officers were scouting for him until they got to wind that during the night he had made his way to his mother's house. And this is a demonstration of the capability of the accused person. Yona, I would wish to speak for the victim. I know Mr. Omar is here. And to ask the court, yesterday when we were in court, members of the, I don't want to say they are members of the family, but they were coming for the accused person. They took videos which ended up on sites like Tuko. And these efforts are just re-victimizing the complainant. We wonder what will happen if he is let out at this point. A mockery is being made of this case. Actually, when this case is such a serious offense, in other jurisdictions, it attracts even a penalty of death. Yes.
Which jurisdiction?
In the states, I don't know which. Almost all states in the U.S.
But you appreciate being Kenya.
Yes, I do appreciate. But that is why we borrow jurisprudence from others. And a mockery of what happened to the complainant is what is being propagated. And lastly, on the seriousness of the offense. The fact that a 57-year-old policeman was given service to the Republic of Kenya for over 4 decades, was assaulted while in uniform, dragged down. And this pained the members of the public who were there. But they chased after the accused person. This offense is serious. It sends a message to the entire country. How do we treat our officers? How do we treat any member, any public servant? And it is my position that we have laid compelling grounds before you to deny the accused person, especially praying for the court to have the requests of the complainant at heart, who is the victim, to first testify before any consideration of the application for bond can be considered by the court. The same is in the interest of justice to be all.
Within the same team, on behalf of the victim.
Yes, Your Honor. Perhaps before Mr. Omar addresses you, and now that he has confirmed that he's on the same team, you need to give the scope and direction to the scope of his participation pursuant to Section 9, subsection 2A of the Victims Protection. In our humble view, Mr. Omar at this particular stage has no audience before you. With respect to the matters before you. This was held in the case of Waswa versus the DPP in petition number 23 of 2019, the Supreme Court decision, at paragraph 7. Having confirmed that he is with the DPP, he cannot be a secondary prosecutor. his role must be very well defined. And he can only address the question of how will the granting of bail affect victims, if at all there was a victim. Because that now is an allegation that a victim exists.
So I think the jurisprudence on the victim, the role of the victim or the place of the victim in the trial process.
That's correct.
It's not in doubt, yeah?
That's
and
correct.
I think that citation you cited, I think it's a guiding light on the issue of the victim. But obviously, I think the ratio in that matter is that the scope of the counsel watching brief of the victim is quite limited.
Yes, sir.
Because they cannot take the role of the DPP, as much as he was just about to be a DPP. Yeah? Assume the role of the DPP is that matter. Yeah?
Yes, yes.
So I think Mr. Omar will be very limited because I believe the other counsel actually argued very
Your Honor, I know exactly.
And Your Honor, before he submits, he can only submit on paragraph 8, clause E of the
that's
affidavit.
all what he has to say. Yeah, and then
Because that is what touches on the victim in this particular affidavit.
Your Honor, I do confirm that that position of the DPP is not available for the next 7 years. So let him not worry. I'll address my point based on the complainant and the victim. I want to define who I'm addressing on behalf. The assaulted police officer is the complainant in this matter. His voice before the decision on bail the family of the victim voice officers in this country. That is the family of the complainant. Their voice needs to be heard. Let me start with the complainant, Your Honor. The charge sheet in count 2 reads that on the 2nd day of June 2024, Committee Road in Kasarani sub-county within Nairobi County unlawfully did grievous harm to one Jacob Ogendo. The complainant was grievously harmed. The import of that, in the event he dies, within 1 year and 1 day, the accused shall stand charged with the offense of murder. That is the first angle. Number 2, the effect of those injuries need to be ascertained medically to bring into perspective the seriousness of the offense. Third, Your Honor, the victim is a 57-year-old police officer with children, with the wife, with the mothers-in-law and the fathers-in-law, with the uncles, who are looking at him, one as a failure, two, a 57-year-old brought down by a 19-year-old. That effect on his self-esteem is devastating. He will definitely need a lot of counseling. That is trauma that cannot be taken lightly. Then I could have taken an affidavit from the complainant to bring to you. He's unable to swear that due to the beatings and the medical condition he's in. You know, on behalf of all the disciplined forces in this country, their creation is a constitutional organs that are created by the Constitution. Article 244 and 245 of the Constitution creates the National Police Service with the mandate to provide internal security. The symbol that Kenyans gave them for identification is the crown. The police officer assaulted was wearing the symbol of national security, the crown. The attacker did not attack a policeman. He attacked the national sovereignty of the republic. He attacked 55 million Kenyans, including himself. That is how grave this attack on a police officer is. You know, what is the net effect of that attack? The American police services failed in Haiti. The world picked Kenya to provide police to go to Haiti. A confirmation that the Kenya police is the best trained. This image globally is a serious dent to our reputation as a country. our pride as a nation. So, the victims who are the police officers and all disciplined officers in this country, if they were not excluded from Article 37 of the Constitution to go picketing and demonstrating, by now all police officers could be on strike.
We invite them.
But we stopped them and told them Article 37 is not theirs. They are coming to you because that is the only avenue available. But don't release the accused person. You're on a fourth. The accused person, if released through the Oscar Sudi decision by just professor, but the police must continue providing security. Show me the practicability if you release this person, the public, from lynching him. The police will not stay. Therefore, for his safety. And for the safety of an accused person relies on the court.
Your Honor, that is with due respect to my colleague.
You will object.
I'm objecting. Your Honor, you gave parameters, and we are okay with the incitement that he's doing because it's on behalf of the victim.
The
But when it
victims.
comes to the point of now telling us that what will happen to the accused person, unless he has been given those instructions by his client, who he says is so ill, cannot even sign an affidavit, he's going outside your guidelines. I don't think that will be right.
Your Honor, on adding what my learned colleague has said, he has said that these policemen are not willing to protect him.
Yes.
And initially, he had said that they are not on strike. He is confirming that National Police Service under Article 44 are on strike insofar as that young man is concerned, which is very prejudicial. And this court cannot entertain such submissions from an advocate holding brief for the complainant, regardless of how emotive the matter is. This is a court of law. Someone cannot come here and say that the policeman that this young man pays through his taxes cannot protect him. That is wrong, and Mr. Omar should recant that such statement.
Your Honor, additionally, I sought your guidance whether Mr. Omar's submissions should go outside the scope of paragraph 8,
It's about the victims.
paragraph E. If he would limit himself to that paragraph, this halupalooza that he's submitting on would not be in a position. You know, when he says that the young man cannot be protected by the police, and then you are being told don't release him, will you go with him to your house? Will you not go with him? Will he not be taken to prison should you decline to grant bail? Are those not police officers? Where is the young man safe? Then unless Mr. Omar takes him with him to his house.
Your Honor, just before Mr. Omar proceeds, you have given parameters now which an advocate watching brief can proceed, Your Honor. It will be good for this court to stamp its authority.
Yes.
It is for such submissions, Your Honor, that the Supreme Court limited the role played by the advocate watching brief. He may be free to submit about the father-in-law, the mother-in-law, the cousin of this, of the police officer. But he should not be permitted, Your Honor, to purport to be speaking for the accused person who is ably represented. Do not mourn more than the bereaved. Do not wail louder than the owners of the funeral. We have our time.
And I think I've not gone outside the parameters of the victims. I'm talking on behalf of the victim, not the DPP.
How many victims are here? The family, the police,
Father-in-law.
the father-in-law. How many victims are here?
I have said in this matter, all disciplined officers are victims. All of them.
Your Honor, that is where you need to draw the line.
And we need to then elaborate.
The charge sheet is very clear. The national, Mr. Jafet Javere Koome, is not a complainant. And my landed junior here is saying that the entire police service, or the entire, I don't know what, he must show us. And he has the charge sheet. Let him read that the entire police service is a complainant. He is only actually trying to poison the mind of this court by trying to show as if this world is coming to an end because a policeman has been alleged to have been assaulted by a citizen. Well, they're even invoking American jurisdiction, where we saw direct shooting, killing a demonstrator in the streets of America.
You know,
that's the type of things that Mr. Omari is opening a Pandora's box because he's excited of the media. Kindly let my landed junior restrict himself.
Mr. Omari, don't be superfluous in your scope is limited. Now you're trying to shift to the accused, because you're saying if the accused is released, I think that is beyond you. So just limit yourself, because I granted you, because I think a victim plays a very integral role in this proceeding.
And very limited ones.
And of course, limited.
You know, I've been told I'm junior. And I admit that. I'm junior.
The president of the
I accept.
That is not in contention.
I'm the junior most advocate. But listen to that junior most advocate. Does he give what matters? It is not when you sign the roll. It is what comes out of that brain. You know, while I'm raising this issue, charge account number 1. It's robbery with violence. And the particulars are that with others not before court robbed Job Ogendo of the battery of police communication gadget and a mobile phone. The import of a police communication gadget in the possession of an accused person is a grave national security issue. That is the person you are being told to release. And I urge the court to take judicial notice that police communication gadgets are a serious tool for the preserve of the police.
Again, Your Honor, we object that line of argument.
Could I get a checklist what they want me to talk to?
Your Honor, I think
they're objecting to everything.
He's now going in matters that are out of his control.
That of
the affidavit is very clear where you are supposed to confine yourself to. Where do
Your Honor,
we have not even been started with the gadget he's talking about.
Was in the hands of the victim, my client.
So you know those allegations.
Yes.
So let's not, it's a factual matter.
Perhaps to manage as Your Honor, you could give us indication of.
Let me give.
If you gave Omari perhaps 2 minutes, he may be.
I have only 1 more minute to go.
All right, let's give him the 1 minute.
I have only 1 more minute to go. You know, the victims cry that before the court renders itself on the suitability of the accused being granted bail or denied bail, the court orders for a pre-bail report to bring to the attention of the court the actual circumstances within the community, within the family, so that the court will arrive at a fair and just decision to deny or to grant. But on behalf of the family, on behalf of the complainant, we completely object for the accused to be released on bail and his prayer is that he be allowed to testify. If the court will be inclined to grant bail or bond after he has testified and given his version before this court. That's all.
All right, thank you, Mr. Omar. Now, that concludes the first team of the DPP and the executive. So we'll go to the
Yes, Your Honor, we will be submitting, but we will take very limited time because we will really wish the court to make a decision today in this matter, and I know the issue of time is an issue. Your Honor, first of all, we submitted extensively yesterday and took a lot of your time. In persuading you, Your Honor, to find it fit to admit the accused person to reasonable bond, terms or cash bail options. So, Your Honor, I would want to adopt, and that is the position of the defense, the submissions we made yesterday, mutatis mutandis, but over and above that, Your Honor, based on the Your Honor, we will demonstrate that in this affidavit, Your Honor, it is the prosecution itself, as opposed to the victim or the investigating officer, that is perpetrating this. Your Honor, the prosecution, and it has made it a habit, I wish JVT was here, they have made it a habit to actually yell more than they yell the loudest, yet they are outside their collar. Your Honor, on record. No, that's off. That's off.
As we don't object.
Yeah. Your Honor, if you look at the reasons that have been given, first of all, in terms of the legal parameters, Your Honor, we are all in agreement that bond is a constitutional right. We do not need to regurgitate that. The only thing you've been told, Your Honor, is that it indeed can be limited. And Your Honor, my brother JV rightly pointed you to Article 24(1). It's very clear. it gives the fact that yes, a right can be limited, but it cannot be limited except by law, and the second qualification, which is very important, only to the extent that that limitation is reasonable and justifiable in a democratic and open society, the prosecution is not Your Honor, only to the extent that is reasonable, justifiable in an open and democratic society, based on human dignity, equality, and freedom. And Your Honor, you've been further, and that second qualification is very important. It has always guided courts dealing with this matter, dealing with such objections and English from the prosecutors, to still affirm that you still have, they still have to convince you that that is the only available recourse in the circumstances. And to that extent, Your Honor, at this particular point, you have been given what they call compelling reasons. Your Honor, what they have told you are compelling reasons. Your Honor, you find them in only one paragraph, and there's a paragraph therein. That is paragraph 8. Your Honor, you are told that the accused person, and the words used, went into hiding. And Your Honor, once you are told he went into hiding, what is not indicated in this affidavit, and that indicates the mischief in this affidavit. What you are not told is where did they find him? How long did it take to find him? But Your Honor, if the submissions of my learned sister, Virginia, are anything to go by, she has told you they found him in his mother's house. In his mother's house. Being a student, that is his place of abode. But they did not put it in this affidavit intentionally. Your Honor, if I leave this court and go to my house, that is the first place you'd look for me, or my office. Logic tells you that. But you are told going to your house is hiding. Then all of us hide at night and come back in the morning. So to that extent, Your Honor, we are humbly submitting that that is not evidence that he's a flight risk. But more importantly, Your Honor, you have been told that even if you are to take judicial notice of that clip, and they are saying one of the reasons that he was being chased by other people who were there. So to them, they would have been happy to tell you that he was chased or stayed there as a fool and was beaten and he died. If you are being chased man, the nature of man is self-preservation. So even that alone will then dictate the circumstances under which then he was not at that scene, if that is anything to go by. And Your Honor, members of the public are relative. Kenya is made up of, I think, 55 million people at this particular point. So a batch of 3, 4, 5 people cannot be a representation of Kenya. So that when you are told there is imminent danger of public agitation as against the accused person, Your Honor, you would want to get the basis of this. What is the basis of this? Your Honor, the requirements of the Evidence Act and this Oaths and Statutory Act declare on an affidavit. You must exhibit proof of what you are averring. This affidavit is naked, Your Honor, as naked. And we've seen better affidavits from the prosecution. That tells you these people did not have any reason. They just did it because you granted them leave yesterday. This is an 11-page affidavit. And I've never seen JV in a matter with an 11-page affidavit, but it's okay, it's not here. Now, to that extent, Your Honor, you look at the 11 paragraph affidavit, and the first parts are just descriptions. But to that extent, Your Honor, when you are told that this person is a danger to the public, is a danger because of the public, let me rephrase it, because of the public agitation against him. Your Honor, first, it is the duty of the National Police Service to protect everyone, such that, Your Honor, what the deponent here is telling you is that that duty is a duty that they can exercise at the point that they want. They have a switch of on and off. That cannot be a reason, Your Honor, for you to say that based on the fact that you will not do your work, I will not grant him bond. Because if you don't grant him, where is he going? He's not going to Omar's house, as my colleague has said. He's going back to the police, because they are the ones in charge of the remand. And these are people who are telling you, we will not protect him. Actually told you, we will not protect him. Your Honor, you are the only one who can protect him then. Police have said we will not protect him. They should not then be seeking to detain someone that they have said they will not protect. And Your Honor, while we are submitting on that, Your Honor, and there is evidence that not only have they refused to protect, they are at the center of circumstances of injuries to the accused person.
Objection, Your Honor.
Let me just...
My objection is simple, Your Honor. Matters of fact should not be coming from an affidavit or the accused person allegation.
Fair enough, Your Honor. If he had waited, Your Honor, you gave an order that the accused person be taken to hospital. That order, we had been told by the remand officers that that order is back here with a report from hospital. So if my colleague has not looked at it, he will have a chance. But I'm court.
Give us the letter.
Your Honor,
Your Honor,
Your Honor, it is with the remand officers.
substantiated with because we're not experts, we're not doctors.
We looked at it, and I'll get back to this because we are not leaving this issue. This person can't chew even mirror that has been back. I will. Yes. Your Honor, to that extent, we have the aspect, Your Honor, that you are told that he's actually in danger. And then you are told that, but this is the public. And Your Honor, the reason for this victimization is what J.V. Owiti was telling you here. That the basis of this charge, and we have said it here, it is anchored on an illegality, corruption. It is anchored on quicksand. Demanding a bribe of 10,000 from a student.
Objection,
Your Honor, it's okay. It is okay. I will leave it there. I will leave it there. But it is there is judicial notice. Remember, they claimed on judicial notice.
Your Honor, if I could assist my colleague, when Owiti was submitting on that, he's the one who preempted the issue of 10,000 bribe, so that they cannot, one of their colleagues cannot be saying this and the other one saying the opposite thing. It was raised by yourselves and you must live with it. Kindly.
My brief response is that Mr. J.V. brought it to the attention of the court that it will be raised. He did not raise it. He said that they will raise it. And if they raise it, they should raise it through an affidavit. If not through an affidavit, through a report being made to IPOA, who are the investigative bodies of such issues.
Your Honor, let me save time, because I know what they want is to delay us and to delay the decision that will release my client. But Your Honor, even taking from what Virginia has told you, that in certain countries, she told you that such acts will lead to death. Your Honor, acts of corruption take judicial notice. In other countries, those public officers are lynched, leave alone being pushed to a trench. So these issues, Your Honor, you must look at them based on what is before you in terms of evidence. Your Honor, in terms of what you are being told by this indicated complainant, you do not have an affidavit. Because this is a person who should have deponed. In this affidavit that is before you, there is no indication that he's unable to do an affidavit.
You know, I did explain that he's in hospital, and we could have said, let us adjourn these proceedings until he recovers. He swears an affidavit. We have no problem. We can stop it here so that he swears an affidavit.
I think what we're relying on is what is before.
Is what is before.
So let's not impute that there are other affidavits. Yeah?
Yes.
So let's just limit, because that is the application. They are saying we're relying on this affidavit by the IU. We're relying on the affidavit of the complainant. So just limit it to what is before.
Your Honor, with respect,
Yes.
when the advocate of the victim spoke, he spoke extensively, and it is our duty to draw your attention, Your Honor, that there are matters of fact which he has pleaded that are to persuade you to deny. So all we are saying in response to all that is that if ever it was to have any probative value, it will have come in an affidavit format. And even if there was difficulty, which you will understand, at least it will have been in this document, such that those averments, Your Honor, have no value in law vis-a-vis the bond application in respect to the accused person. Your Honor, you have been told, as I wind up on this particular aspect, Your Honor, that indeed, if you look at that affidavit, and I'm happy you are drawing your attention to the affidavit, the deponent here, Your Honor, is not deponing independently as is required by law. He has actually told you in paragraph 10, and I would want to draw the court's attention, because this is now a legal issue. Your Honor, the deponent of his affidavit does not even believe that there are compelling reasons. His affidavit is based on what he has been told by another person who has not deponed. And he has not told us who specifically told him. Look at paragraph 10. It tells us that I have been informed by counsel handling, which information I believe to be true, that the reasons given are compelling enough so as to deny the respondent person bond. So this is a person himself, as the IO, does not even believe. So it is the fitina from this person called counsel that has been brought here and is actually telling you this is someone who I believe.
You not kindly protect counsels
no,
and
no, no,
state
no,
officers.
no, 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 no,
Fitina
no,
is
no,
a very derogatory.
No. That is the Kiswahili word. Your Honor, I got a name Kiswahili. It is malice, it is gossip, it is hearsay. That is what I will rephrase it in those three words. It is gossip, it is hearsay. If that will make my brother happier. So that, Your Honor, the requirement under the Evidence Act is that it is this investigating officer who must first satisfy himself that after investigation, as he has indicated in the paragraph 6 and 7, that I actually can aver that this person, there are compelling reasons to deny him bond. But the person who has come up with these reasons is someone who we do not know, and now they are running away from. I will say it's not them, but whoever it is, Your Honor, that person is not before court, and you cannot then rely on this affidavit in terms of the strict sense of the Evidence Act. This is not an affidavit that can be relied upon. Your Honor, there are a lot of things that you have been told, Your Honor, and this is not the first case dealing with granting of bail or bond terms under the 2010 Constitution. It is not the first one, it will not be the last one. And neither is it the first one that the DPP is opposing. I've said they are used to opposing. Even the case that JV told you, they opposed up to midnight, but they were still granted bond because the Constitution, Your Honor, I submit, fights for all of us. It will fight for me today, Your Honor. It will fight for Ian Njoroge today. But the same Constitution, Your Honor, can fight for any of us in this room. And we have represented even magistrates with using this Constitution, and I've been with my brother.
Is that supposed?
No, it's off the record. You know, they've said everything off the record. But when we go off the record, something is pinching them in the chair. I've represented, even with my brother here, we've represented. And that's why, Your Honor, when it comes to the Constitution and the rights of an accused person who is innocent, Your Honor, we become very passionate on that, Your Honor. It may be the gravest of allegations, but, Your Honor, the principle of innocence until proven guilty must always be affirmed. And that is why Article 24 is there. So that regardless of who is in power today, regardless of who is on which side today, this Constitution will always have the same terms, looking at the circumstances of the matter. Your Honor, that is all. I really beg you to grant the accused person bond terms, but my colleague will actually touch on legal issues as we proceed. Thank you so much.
Thank you very much. I'm going to address you on the so-called seriousness of the offenses. And this has been glossed over by Mr. Owiti, Mr. Omari Datsan, and Madam Karaoke. Your Honor, they have not tried to rebut the submissions on the Kahinga case. On the 15th day of March 2018, Section 297(2), which Mr. Omari would like to rely upon, to demonstrate the seriousness of these offenses and hence denial of bail, favorable bail terms, was declared unconstitutional by a bench of 3 judges. That is not denied. We submitted on that extensively yesterday. We have not touched on it. Your Honor, you will be persuaded that in petition, it's a petition, it's a petition pending before the court for the ODPP to be compelled, and the Attorney General to be compelled to adhere or to do exactly what they were advised by the court within 18 months, failure to which the orders that were sought by operation of the law become the law. Section 297(2), which carries a death sentence, does not exist in Kenya. It does. Your Honor, I'm being heckled that it does by none other than my learned junior, Mr. Omar. Oh my God. In petition E036 of 2024, the gravamen of that particular petition is quite different from what was being sought in petition, the Kahinga petition that was declared sections 295, 296, 297 to all unconstitutional. Why? Because of lack of specificity on which the young man in the dock should prepare himself to answer. The court told them in no uncertain term, go and remove the ambiguities. Those ambiguities have not been removed, and you are being told that consider that ambiguity in section 297(2) to deny the accused person bail. That should not happen in a democratic republic. Your Honor, you have been persuaded that the alleged victim is a 57 years old officer who has served this country for 40 years, 4 decades. Those are the words of my learned sister. The importance of this police officer, Your Honor, should not or ought not to have come when he was attacked. He's a corporal. If they really valued his services to this country, they ought to have promoted him to a level of sergeant, at least, if they so much care about him. That persuasion is for you to read the emotions.
Kindly, my senior, though he has never been promoted to senior counsel, is still attacking the victim. I'm appealing the victim to be protected. My senior counsel.
But you brought the victim to court.
I'm only looking at promotional issues. Career progression have no business in this matter. Neither is it an employment and labor relations court.
Your Honor, they brought the issue of the age. It is in the affidavit, and they don't want us to go there. But we can forgive Mr. Omar for that oversight. Your Honor, you have been persuaded that this matter was in Tuko, it was in this radio station, it was in that television station by my learned sister, Miss Njoroge, Miss Karaoke. Your Honor, the reason why the prosecution is very, very persuasive, or they would really want this matter to go on in darkness. They would really want this prosecution to proceed in darkness because these members of the press are, together with this court, are protecting the victim, the accused person. They would really want this matter to be held in darkness. Yesterday, immediately after you gave directions, the same prosecution dragged the accused person to the traffic court, where at least that court is a bit reasonable.
I am objecting that you are being accused of dragging somebody from court. You know, those are grave allegations.
I think let's be cautious on how we make this argument.
Your Honor, what do you call, which adjective would you use on someone who is handicapped being taken to court. He's being dragged there. I don't know which adjective my Mr. Ashoka would want me to use to make them look better, because they are already bad.
I'll assume that's a metaphor. So let's just
yeah, it's a metaphor, and they claim to have. Anyway, that's a metaphor, Mr. Ashoka. Thank you very much, Your Honor, for guiding. Your Honor, the accused person was taken. Let me use the word. If the drug is was taken to the traffic court. At least that court, the prosecution there was very reasonable. They did not oppose the release of the accused person, who was charged with 3 traffic counts of causing obstruction, carrying excessive passengers, and disobeying verbal directives. Your sister magistrate, Madam Nanzushi, was graciously to grant us a cash bail of 60,000 shillings. They did not oppose it there. The reason why they are opposing it here, it's because of fitna, and fitna is malice, the particulars of which you have given. Sisi tumesoma Kiswahili na ibara ya 8 inasema Kiswahili ni lugha ya taifa na ni lugha ya ofisi. Kwa hivyo tunasema ni fitna, tumepatiana sababu zenye tunajua ni fitna, kwa sababu kama hawakupinga dhamana kule, sijui ni kwa nini wanaipinga hapa. You know, throughout the submissions of 4 state agencies, including Omar, because he called himself state agencies, they all relied on section 60 of the Evidence Act, forgetting that that section does not belong to the sovereign, as they call themselves, forgetting again that not even to the state agencies themselves. That is Article 2(1) of the Constitution. Your Honor, you a video or something was posted by Mr. Sonko. We do not know the relationship between Mr. Ashoka and Mr. Sonko. And maybe Mr. Ashoka and Mr. Sonko are in connivance.
Objection.
That's judicial notice.
Objection, Your Honor.
Judicial notice on the social media for Mr. Ashoka to come and rely on them here, Your and Honor, say
Mr. Lempa on his feet. You sit down. Your Honor, I do not wish to be dragged into this case as a party. I only brought it to the attention of the court that there are social media so that there is interferences of witnesses, and I asked the court to take judicial notice about Mr. Sonko.
Yes, on judicial notice, Your Honor. It's very clear. All the witnesses therein are police officers. Mr. Ashoka did not lay any basis that Ian Njoroge is likely to interfere with police officers, as it has been demonstrated. So that when you are Mr. Ashoka did not lay any basis that that particular posting by Mr. Sonko was posted by agents of the accused person. That's the point I'm driving. And because it is judicial notice and therefore speculative, we can speculate either way, that it has been made by the prosecution, and as Mr. Ashoka was claiming, was posted by ourselves, which we are denying that we have nothing to do with Mr. Sonko in these proceedings. So therefore, in conclusion, the prosecution and the National Police Service are the aggressors who are weeping louder than the bereaved. In those few remarks, Your Honor, there are no compelling reasons whatsoever to deny an accused person regardless of the person who was attacked. Article 24 is very, very clear that the limitation should not derogate from the core content of the right, and the right here is to be granted bail. So therefore, we persuade you, tafadhali mheshimiwa, muachilie kijana huyu kwa dhamana. Hakuna sababu zozote zimetolewa. The seriousness of the offense, we have only 2 counts in this particular charge sheet: grievous bodily harm and resisting arrest. Hiyo ingine ni fitna, as we have demonstrated here. It does not exist anywhere in the books of law. 8 years down the line, 8 years down the line, the defense and the sovereign, as Mr. Omar would like it, have wamezembea kasini, wamelala. They were given 18 good months to go and cure the ambiguities, and now they are bringing you the ambiguities, Your Honor, and telling you, Your Honor, deny this young man cash bail on our own ambiguities. Your Honor, my last, this reminds me of section 84 of the old constitution, where the former Chief Justice was to develop rules to enforce section 84 of the Constitution, which was chapter 4 of the Constitution of Kenya. Cecil Miller declined to develop rules, and when an application was taken before him, he said that there are no rules to enforce what? Fundamental. To Mr. Omari, Mr. Ashoka, and my good, as the defense, as they call themselves, kindly do not consider that line of submission, that there are serious offenses before you. In any case, the death which Mr. Omari is alluding to, that should the officer die within 1 day, 1 year, 1 day, the accused person would be charged with murder. That is speculative. And Mr. Omari, unfortunately, he did not say, God forbid. Maybe he subscribed to my own belief that God is not obliged to answer our own prayers. Thank you very much, Your Honor.
Yeah, Your Honor, I'll be very brief, noting that it's almost getting to 5. And while submissions were being made, Your Honor, I had an opportunity to discuss a few issues with the accused person. He confirms to me that the allegation or the offense is alleged to have happened at about 8 a.m. So I inquired where he went immediately after the incidents. He says he went to his mother's house. Objection, Your Honor. Matters of fact. My learned friend is a very senior advocate. He knows the procedures of laying evidence before court. It's through an affidavit, or the accused person should take the stand and make those averments under oath. They should not be coming from the bar, Your Honor. Your Honor, mkuki kwa nguruwe mtamu kwa binadamu. Waswahili wanasema kwamba ni mchungu. He made similar submissions. I'm only giving the account of what transpired to indicate to you that the accused person before you is not a flight risk. He confirms to me they went had lunch with his grandmother and his family at about 1 a.m. At 6 p.m. they went back to the house. At 8:30 p.m. the police
get an opportunity to cross-examine counsel, because those are matters of fact.
Well, I'll proceed, but the court has taken note of the account that he was thereafter arrested at 8:30 p.m. while still at his mother's house. That confirms to you, Your Honor, that the accused person before you is not a flight risk. You've been invited to look at the status of the victim, the alleged victim, his age, his time, period of service in the police service. But that has never been a consideration while evaluating the compelling reasons under Article 49. You've been asked to deny him bail on the count of his safety. You've been told that the only place that he can be more safe is with the police. We have allegations that the police have assaulted our client. And we are the complainant.
I think a correction will be not detained with the police at all. It is custody. Custody is manned by the prison.
Well, to the best of my knowledge, you addressed Article 244, Mr. Omar, for your information. You will be under the custody of the police, as defined by Article 244 of the Constitution. If then he is not safe with the police who have now assaulted him, my running friend Mr. Okach was asking us, where is he safe? I want to submit that safety is not determined by the status of the victim. Further, Your Honor, I want to address you on paragraph 8, clause E. The DPP states that the complainant, who is 57 years old, feels victimized on social media and requests to testify before the accused person is released. It has not been alleged that our client is responsible of those social media publications. And he has not disclosed the source of the said victimization, nor has he associated it with our client. We submit therefore, Your Honor, that there is no jurisprudential value in alleging that he needs to testify first, so that then you can consider granting our client bail. You know, if the alleged victim feels victimized, my learned friend Mr. Omari knows the existence of Section 4 of the Witness Protection Act. They have not taken advantage of that provision, so that, Your Honor, if it is true that he is threatened, then they can take the necessary actions to commit him to witness protection. Your Honor, Section 4 provides, subsection 2, that without prejudice to the generality of subsection 1, the actions taken under subsection 1 may include, but not limited to, physical and armed protection. That is what the law says. That you can have physical protection, or you can even arm that particular witness. This is a police officer, fully armed, and therefore he qualifies under Section 4. And as such, Your Honor, I join issues with my learned friends' earlier submissions and urge you to disregard the submissions by the DPP. They are only meant to whip emotions. Disregard the submissions by my learned friend Mr. Omari. They are not factual. They have no basis. And we remind Mr. Omari that the world did not take Kenya to Haiti. Kenya took itself to Haiti. And as such, there is no prevailing reason that may invite you to decline to grant bail. You know, the proposal for the pre-bail report, as proposed by counsel, has not been brought out through an affidavit. It's not an averment that is contained in the affidavit by the DPP. It's a creation of my learned friend Mr. Omari. He had the advantage of meeting his client. He had the advantage of bringing up an affidavit, but he declined and refused to seize that moment. You know, it is not disputed that the accused person has a permanent place of abode. Actually, it has been confirmed by the DPP that he lives in his mother's house. It has been the tradition of this court to ask the accused person to provide two contact persons. The parents are well suited to make sure that the accused person shall not jump bail. They are here before this court, Your Honor. They are capable of standing surety to ensure that this accused person fights or have his day in court. Finally, Your Honor, whatever happens outside this court, the court is blind to those particular facts. The court is only alive to the pleadings before it and the submissions and the averments made by parties before the court. In matter of fact, Your Honor, if I would be dramatic, slightly dramatic.
Don't be cancelled. Please don't.
The people of the Republic of Kenya in support of Ian for having fought corruption or alleged fight corruption. The bitterness is not with Ian, but with the issues happening in this country, among them the heavy taxations. And as such, Your Honor, we pray that you grant Ian bail. The public will vent its anger against the regime in its own way, and Mr. Ian has nothing to do with that. I invite Mr. Secha to make briefs.
Thank you, Your Honor. I will start, Your Honor, by introducing the accused person before you. He is a 19-year-old student of Sunshine School, currently a first-year student of civil and structural engineering at the Technical University of Kenya. He is a Christian, a member of the university choir and Christian Union. Having introduced the accused person, Your Honor, I'll address you to what the prosecution purports to be compelling reasons. And as I address you, I want to go on record that our guiding document is the Constitution, and that the cardinal consideration when issues of bond and bail are being canvassed is whether the accused person will be able to attend court or not. That is the primary cardinal consideration. The rest are secondary and tertiary considerations. They have not denied that he's a student. What they have said is that his only crime, he ran away to his mother's house. Did they expect a 19-year-old to have a home? He is available. He will attend court dutifully as and when he is required. Your Honor, then the prosecution goes on a trajectory of wailing louder than the bereaved and saying that the accused will be insecure. Your Honor, it is settled law. And I will quote the dictum of Ouko J, as he then was, in Nicholas Kipsigei Ngetich and two others versus the Republic. While the prosecution raised such issues, and while frowning at the issues, the court said, it is the duty of the state, in terms of Article 29C of the Constitution, to ensure the safety of all citizens.